All right, this is People of the State of Michigan versus Jason Levesque, case number 253852 SD. We are here for a bond violation hearing. Since we were here yesterday, a couple more allegations have been added, so I'm going to go through the allegations again. They are that the defendant failed to appear for a random alcohol test as ordered on 9/3, 9/6, and 9/8. And I believe we're here for a contested hearing. Is there any resolution in this matter? No? All right, Ms. Lawrence, your first witness. Solemnly swear or affirm the testimony you give in this matter will be the truth, whole truth, and nothing but the truth?
Yes.
You may have a seat. And whenever you're ready, Ms. Lawrence.
Please state your name for the record.
Alex Mansky,
And where do you work?
Community Corrections in Oxford County.
Is Jason Levesque under supervision with your office?
Yes, he is.
And is that bond or probation?
Bond.
And is random alcohol testing part of his bond conditions?
It is.
And when did he come to community corrections to sign up for testing?
He enrolled in testing on August 29th.
And do you go over how random testing works at that stage?
We do. They're given a rule sheet and an opportunity to ask questions.
Okay. And that rule sheet explains to the defendant how he checks in for random testing.
That's correct.
And did he have any questions for you at that time?
Not that I wrote down, not that I recall.
Okay. So to your knowledge, he was aware of how to check in for the random testing.
That's correct.
And was the defendant supposed to come in for random test on September 3rd of 2025?
Yes,
And did he come in?
he did not.
Was the defendant supposed to come in for a random test on September 6th of 2025?
Yes,
And did he?
he did not.
And was the defendant supposed to come in for a test on September 8th of 2025?
Yes,
And did he?
he did not.
I don't believe I have any more questions at this time.
Thank you. Ms. O'Mara.
You mentioned the sheet that they're given with the rules. What methods of contacting testing do they have on that sheet?
They're to, you mean how
How would they know if they're going to test, I suppose?
they go on our Wexford Community Corrections Facebook group and they're assigned a random number. They check that Facebook group every morning. If their number comes up, then they are ordered to test.
How would someone test if they did not have Facebook?
That would be a question that they would ask at enrollment.
Is that question answered at all on that sheet of paper?
It is not.
Is there a QR code on that sheet of paper?
There is.
If somebody's phone couldn't read that QR code, could their phone read it? Could they deal with that information?
If the phone doesn't read the QR
If
code, then
sorry, I thought it was a bad question. Let me withdraw and say it again. How do you use a QR code?
you can scan it with your phone, but there's also an underlying name that we verbally explain. You look up this name to find the page.
And so if their phone couldn't scan that, they wouldn't be able to use that QR code directly.
Correct.
Thank you. That's a question.
Ms. Lawrence.
Just a few. Regarding the Facebook group, is all of that explained to the defendant when he signs up for testing?
It is. It's written on the rule sheet and I verbally explained as well.
Okay. And I believe you said under the QR code, there's also instructions of how you can just type in the group.
I verbally explained that part. There's the name of the Facebook page is underlined. I believe it's in bold above the QR code. I say, if this doesn't work, you can search this.
Okay. And just to clarify, you don't recall him asking you anything or stating he didn't have a Facebook or anything like that at that time?
I do not. Typically, I'll walk them through it on their phone and I don't recall doing that.
Okay. Nothing further. Thank you.
Thank you. Ms. O'Mara.
Mr. Levesque reported for testing at all?
He has not.
Is the Facebook group public or private? Would you need a Facebook account to view that? To view the page?
It's a public group. I have gotten to it through Google before without signing in.
No further question.
Ms. Lawrence,
I have nothing further, Your Honor.
may this witness be excused?
Yes.
You may step down. Any further proofs, Ms. Lawrence?
No, Your Honor.
Any proofs, Ms. O'Meara?
No, Your Honor.
All right, argument?
Thank you, Your Honor. I think it's clear from Ms. Matzke's testimony that the instructions and testing and how that works in the Facebook group was clearly explained to the defendant when he signed up for testing. That is standard procedure. He knew what he was supposed to do and he failed to do it. He was supposed to test on September 3rd and Ms. Matzke testified he did not. He was also supposed to test on September 6th and September 8th. And Ms. Matzke testified he did not show up for those tests as well. I do think it's clear he was aware of how to check in for random testing and he failed to do so. He has not tested since being ordered on bond. If people would ask the court to find the defendant guilty of all the bond violations.
Thank you, Ms. O'Meara.
Your Honor, as I was trying to lay out there, the claim from Mr. Levesque is that he does not have a Facebook page, does not have a phone that can read that QR.
Well, there is no claim because he didn't testify.
The-
So that's all stuff not in evidence.
It's okay. They would have to prove that Mr. Levesque had a Facebook page. They would need to prove that Mr. Levesque's phone could scan that QR code. No evidence has been introduced that that's the truth, that his phone can or that he has a Facebook page. My argument would be that there isn't evidence showing that he was constructively aware that he needed to look at that Facebook page to find out when he would test. He never went in the test, which is consistent with someone who didn't know that they needed to test because they've never gone in the test. So I'd ask that he be found not guilty.
Thank you, Ms. Lawrence. Any rebuttal?
Your Honor, Ms. Matzke did testify that she has been able to access this Facebook group without logging into Facebook. She testified you don't necessarily need a Facebook account in order to see the group, that this group is a public group on Facebook, and that all of this was clearly explained to the defendant. I apologize, Your Honor.
No, you're good.
Ms. Matzke also stated that he had the opportunity to ask questions at that time, and he did not do so. It was on the defendant to inform community corrections whether he wasn't able to access the group or didn't understand any of the instructions, and he did not do so. Thank you.
Thank you. The court, having heard the arguments, I do find that the defendant, or arguments and testimony, I do find the defendant is in violation of his bond conditions for failing to test on September 3rd, September 6th, and September 8th. In particular, the magistrate on August 29th arraigned the defendant on a drunk driving charge or operating while intoxicated. Bond had been posted at $250, and that was continued with the added provision of no alcohol in random testing. We heard the testimony of Ms. Matzke today that she had gone through the enrollment instructions. To the best of her recollection, there was no questions. She's also testified that you do not need to have Facebook in order to gain access to the public Facebook page, as she has gotten it through Google. Defense argues that because he didn't check in and didn't test is indicative that he doesn't have the ability to do so. It's also indicative of somebody who just doesn't want to comply with the bond requirements. So I do find the defendant in violation of his bond. Any argument regarding what we do next regarding bond, Ms. Lawrence?
Thank you, Your Honor. I'm going to still ask for a remand in this case. The underlying charge is an operating while intoxicated, which the intoxilizer was used and it came back at a 0.104. Given the fact that the defendant has not been on bond for very long and he has already failed to test 3 times and has not tested a single time since being on bond. I think it's pretty clear that he is not doing well on supervision, so the people would ask for a remand. Thank you.
Thank you. Ms. O'Mara?
Your Honor, well, I respect that, flow on the point, 104 is above the legal limit. It's not anywhere near the highest we see in this court on a day-to-day basis. I would ask that my client be given the daily breath machine as opposed to the random testing. I would think that avoids any confusion or any perceived confusion regarding random testing. I also think it would become relatively clear relatively quickly whether or not he was going to comply with that bond condition. He intended to get the daily testing machine when he first reported to community corrections, just didn't have enough money to get it at that time. He does have enough money to do it, he just didn't have enough money with him at that time. So I think daily blow machine would be very helpful for Mr. Levesque. I don't believe him to have, I don't think that he was drinking when he missed those tests. I think that he just missed the test out of, regardless of whether or not he should have known, I do believe he did not know. So thank you, Your Honor.
Thank you. Ms. Matzke, the cost for the daily breath machine, that's $10 a day.
Correct.
Is there an upfront fee to that?
There's,
And how does that get billed?
they report weekly, you can prepay for it, but, when we give them the option, they explain that you report weekly, most people pay $70 per week. You can pay ahead, but we do not require that you pay today.
And there've been no, okay, so there have been no upfront cost to it.
We don't require that.
Okay, I didn't think so, but I just want to make sure. Ms. O'Mara, you're back on your feet.
Yes, I'm sorry. I believe there may have been a misunderstanding of that $70 weekly fee. I believe he thought he needed to pay $70 upfront, regardless of whether or not that is he maintains that he asked the person at the front desk that they said he needs $70 upfront. So again, that's where we're at. Thank you.
All right. Well, while the court does find that there's a violation and does have concerns for continued alcohol use, I don't have any positive tests, but that's because he didn't test. To his credit, he did turn himself in. I assume that was when he was informed that he had the warrant out for him. So I am going to allow the defendant to remain out on the $250 bond as previously posted. I am going to amend the bond conditions to a daily alcohol machine, and all other conditions remain the same. Mr. Levesque, I want to make sure that it's very clear how things move forward from here. You are required to report at least once a week to community corrections, and you do an ETG at that time, right?
We do not.
Oh, you don't?
No, and the report can be on the phone.
Okay. So, but you are required to do that report, and you're going to be required to do the daily blow machine, which I believe is 4 times a day.
Yes.
So just so you're aware of that. Question?
So I have to come up here.
She just said that you could report by phone.
I can report by phone, okay, because I live in Jackson, Michigan.
Well, I understand that, but you committed a crime here.
Yeah, I understand.
So, or allegedly committed a crime here. So it sounds like they'll work with you on that. So when you're released today, you're going to have to report immediately to community corrections and get signed up for that alcohol test.
Yeah.
Okay.
Absolutely.
All right. Anything else, counsel?
No, Your Honor.
No, Your Honor.
We are adjourned.
Thank you.
Ms. Aldrich, have you heard what the attorneys have said the resolution in this case is?
No.
So my understanding is that you'll be pleading guilty to what will be essentially an added count 2 of malicious destruction of personal property, 200 to 1,000. In exchange for that, the people will be dismissing the charged offense of malicious destruction of personal property, $1,000 or more, but less than 20,000. There's also a restitution request of $2,387.52. And the charge that you would be pleading to is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000. The charge that you've been charged with is a 5-year felony, which means you could be sentenced to 5 years in prison. Do you understand that? That's the one being dismissed. So you'll be pleading to the 1 year, the 5-year will be dismissed.
Okay, yes,
Do you understand that?
yes,
And is that how you wish to resolve the case?
yes.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. Back on July 2nd of this year, were you on probation or parole?
Nope.
Were you on bond? Is that a no?
No.
Do you remember reading and signing this advice of rights form, talk about your rights to a trial and your rights to an attorney?
Yep.
I need you to answer either yes or no, okay?
Yes. Sorry.
Did you understand those rights?
Yes.
Do you have any questions for me about those rights?
No.
Most importantly, do you understand that by entering a guilty plea today, you'll be given up the right to have a trial and you won't have a trial of any kind?
Yes.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, you're not.
Then, Ms. Aldrich, to the allegation that on or about July 2nd, 2025 in Herring Township, Wexford County, how do you plead to malicious destruction of personal property, $200 or more, but less than $1,000? In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on July 2nd of this year?
My ex, I believed he was cheating, so, out of fear and anger, I kicked his Tesla.
This Tesla?
Yes.
And did it do damage to that?
Yes.
And did that happen in Herring Township of Wexford County?
Yep.
And do you agree with me that damage done had a value of at least $200?
Yep.
Yes?
Yes.
Do counsel believe that the defendants provided the factual basis in which to accept the plea and that the court rule has been complied with?
Yes.
As do I, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Aldrich, I find you guilty of malicious destruction of personal property, 200 to 1,000. Pursuant to the plea agreement, count number 1 will be dismissed at the time of sentencing. Are we able to sentence today?
Yes.
I forgot a component. No, we covered that. Never mind. I'm sorry. Is there any victim impact, Ms. Carey?
No.
Allocution, Mr. Hartel?
Yes, thank you, Your Honor, and just so you're aware, my client's just a little nervous, so she doesn't get any disrespect to the court, but
No.
I am proud of her for being able to be honest with everything. It's a bit of a summarized version of events, but a bad breakup, she shouldn't have done what she did. I'm glad things didn't escalate worse. Sometimes they do in more unfortunate situations, but she has been doing everything she can to be productive. She's not only been coming to court, that is Oasis. Yeah, she's been working with Oasis, who's been coming to the defender's office with her. It's good to have that support structure to make sure one takes the proper steps to avoid these type of situations in the future. She's advised me that she is the guardian of her 16-year-old little brother, and I don't doubt she wants to set a good example for him. So if given the opportunity to be on probation, not only do I think this indicative that she'd do well on it, because she's done well on bond, but she also has those strong ties to the community, working with Oasis, wanting to make sure her brother has that good role model. Hopefully he never makes the same mistakes, but so that he can see that she's going to complete everything successfully. So if the choice between jail or supervision is in the mind of the court, ask the court to consider the supervision. Thank you.
Thank you. Ms. Carey?
Thank you. The car had been borrowed by a friend of the owners, and she walked to that person's house apparently, and did obviously extensive damage. Doesn't take much to damage a car nowadays, and over $2,000 in damage. People are going to ask for a period of probation with an anger management component to this, because frankly, it's pretty concerning. This would happen in the middle of the day, and frankly, there are other ways to handle situations like this, than what she did. So I would ask for probation. Thank you.
Thank you. Ms. Aldrich, you had the right to address the court prior to sentencing. Is there anything you would like me to know?
No.
So what was going on? I know you suspected some cheating happening.
So we were supposed to go to Traverse City that morning and pick up a car. I had slept in that morning and I was not ready. he seemed like he was in a hurry, so I let him go ahead without me. And I had called him and I found out that he had a coworker with him, and he had told me to leave him alone, and then he blocked my number. So I assumed that he was cheating, and at that point, I had thought I was going to lose my home and possibly guardianship of my brother.
And
So
that's, and is the Tesla his?
he makes payments on it. He does not own it.
But he's in the process of buying it? Was it in his possession when you kicked it?
No, it was at the Michael Farkle's.
Okay. But I guess what I mean by that, was he using the vehicle when you kicked it?
No,
All right, all right. So what have you learned from this?
I've learned a lot. I set a really bad example for my brother. I put his safety and on the line. I've had a lot of time to think about it and regret it since the moment right after it happened. Before going through the courts, I had kind of stayed in contact. His Tesla charging was still hooked to my credit card because he didn't have one that he could put it on. I've bought him groceries since then, but before the no contact order. So I've tried to make up for it a little bit, that I could.
How long do you think it's going to take to repay the restitution in the amount of $2,387.52?
I don't know. I was working at the Horseshoe Bar in Marion. Before this had happened, I had put in my 2 weeks. I had asked them if I can continue working for them, and said no. So I'm working with Bill Staffing and trying to get another job. I was kind of hoping maybe I could get a loan and pay it off right away. But I don't know.
So next time we have an urge to do something like this, what are you going to do instead?
Definitely not that. Probably stop and think for a second, collect my thoughts and feelings and control it.
Your brother's 16, you said, and you're 24? All right. Anything else you'd like me to know?
Not that I can think of.
All right. There is going to be a $75 Crime Victims' Rights Fund fee and $50 state minimum fee. I'm going to order a $150 fine. I'll waive the court costs. Mr. Hartel, attorney fees.
We'll waive that till the repay quicker, Your Honor.
Attorney fees are waived. Ms. Aldrich, I'll be honest, as we've been talking, I've been trying to decide whether or not I'm going to place you on probation. I think I'm not going to do that. It sounds like you have a lot going on your plate. About the only thing I could see coming from that would be some sort of classes for anger management. And I think you have a handle on what you need to do moving forward so that this doesn't happen again. So I'm not going to place you on a period of probation. I'm trusting that I'm never going to see you again. And I think I can trust you for that. So there is the restitution in the amount of $2,387.52. There is 1 day jail with 1 day credit. Now, and the no contact order is obviously lifted because there's not a probationary period. Because I have sentenced you to a term of incarceration, even though it's time served, you do have the right to appeal that decision. If you decided that you wanted to appeal that decision and could not afford an attorney to assist you, you have 14 days from today's date in which to request the court to appoint an attorney. Also, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that by operation of state law. And that's even if you're on a payment plan. Do you understand that? All right, you can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on that payment. Okay. All right, good luck.